Alrighty, welcome to the Neb Miller Minutes, where I take an interesting piece of HR, something or other, break it down into digestible pieces to give you a little bit further insight in regards to what happens in the HR world, what's happening in the employment relations world, so you can take something away, whether it be employment law, whether it be a discrimination case, as we're talking about today, or whether it be any other interesting facet of the employment relations world. Let's get stuck into it. So, if you've been living under a rock for the past month or two, you might have somehow been able to avoid the Israel Folau debacle saga. Everything that's happening in the media, the sheer amount of coverage that this case is getting, and for a very good reason. This case is about to establish or set some very, very fascinating legal precedent. Now, Mr. Folau, who, if you are unaware, has damned the LGBTQ community as well as a number of other types of lifestyles or people within our society based on his religious views. His employer, therefore, Rugby Australia, then said, listen, mate, you're fired, get out, because we find what you've said as to be offensive. Mr. Folau's come back and he's now launched a legal dispute with his previous employer, Rugby Australia, as previously mentioned, on the basis of discrimination in the workplace. Now, discrimination in the workplace is a protected phenomenon by the Fair Work Act and by the Fair Work Commission, and I'd love to give you a little bit more detail and information about that so that you can also take this information on board, make sure it doesn't happen to you when you are in the workplace. And I'm going to do a very quick reading from the Fair Work website just to make sure that I don't miss anything and to make sure that I cover everything that I need to cover. So, protection from discrimination at work. Now, Fair Work states that discrimination occurs in the workplace when an employer takes an adverse action, which we'll touch on in a second, against an employee or prospective employee because of a protected attribute. So what are the protected attributes? The protected attributes, as per Fair Work, are race, color, sex, sexual orientation, age, physical or mental disability, marital status, family or carer responsibility, pregnancy, religion, political opinion, national extraction, and social origin. So those two pieces there, the sexual orientation and the religious aspect of the protected attributes list, are really are the two main factors of what is coming into play in this case between Mr. Folau and Rugby Australia. Now, what is adverse action? Adverse action includes doing, threatening, or organizing any of the following: firing an employee, which is exactly what's happened in this case, injuring the employee in their employment by not giving an employee legal entitlements such as pay or leave, changing an employee's job to their disadvantage, treating an employee differently than others, not hiring someone entirely based on any one of those protected attributes, or offering a potential employee different and unfair terms and conditions for the job compared to other employees based on those protected list of attributes. Now, the Australian Human Rights Commission inputs a great deal on our legal system to ensure that mine, anybody else's human rights are protected. Now, their definition of discrimination in the workplace states that discrimination in employment on the basis of religion, as is the case for Mr. Folau, occurs when someone does not experience equal opportunity in employment because of their religion. This may include being refused a role, being dismissed from employment, being denied training opportunities, or being harassed at work. So even the Australian Human Rights Commission states that if you are dismissed based on your religious views or based on your religion, that is grounds for discrimination. Fair Work states the same. So Mr. Folau's court case, his suing of Rugby Australia, sorry, my tongue is getting weird. His suing of Rugby Australia is on decent foundations from a legal perspective. Now, whether or not you like Mr. Folau, whether or not you hate Mr. Folau and his standings, whether you fully support the LGBT community or you're fully against them, whatever your point of view is here, just for the sake of this video, I want to challenge you to put your emotions on pause and to just think laterally for the next little bit. Now, what is very, very important is the outcome of this court case, because that will do will set case law. So within this country, there are laws that are set up based on the arguments or the legal battles between two parties and the outcomes of those parties. That's case law. It's legal binding precedent. So what that means is that if Mr. Folau wins his case. We'll start there. So if Mr. Folau wins his case, so he goes up against Rugby Australia, he wins the case, his legal team is able to prove that Rugby Australia took adverse action against him in the form of firing him from his employment based on his religious views. That will be huge. That will either win or loss, either will be huge because of the legal ramifications of what's going on. Now, if he wins, it means that a very strong and very clear message will be sent out to the employment community, to all employers everywhere, to back off their employees' religious ongoings and expression of their religions on social media platforms. Instagram, Facebook, Snapchat, LinkedIn. I'm not sure what else is out there, but whatever else is out there. If he wins, it will mean that there is case law, there is legal precedent to inhibit or to stop an employer from firing their employee based on that employee sharing their religious views, whatever they may be, on a social media platform. Now, again, let's move away from Mr. Folau. Understand that that would mean religious expression, freedom to express your religion for Muslims, for Christians, for people of the Jewish religion, for Shintoists, Taoists, Catholics, Protestants, you name it. That would allow them to freely express their social media, their religion on social media, without fear or retribution of it impacting on their employment. Now, alternatively, if Mr. Folau loses, which I assume most people, from what I've seen on social media, from speaking to people, most people hope he loses. Now, again, let's think laterally here. Take away your feelings about Mr. Folau out of this equation. Now, if he loses, the legal precedent will be set for employers to be able to terminate their employees based on their social media sharing and posting and interaction that's linked to their religions, meaning that if the person that's in control of the workplace where you work states or thinks or comes across and says that's offensive to this person or to that person, to this community or to that community, you're fired because you shared your religious views on social media. If Mr. Folau loses, that could happen more readily within Australian workplaces. So the question that we really need to ask ourselves is, which way do we want to go? Do we want to go down the path where we say we Australians want anybody and everybody to be able to share their religious points of view on social media, express their religious thoughts without retribution of any sort, and that's the way that we want to go? Or do we say, no, we want to make sure that if you're posting something on social media and it's offensive, regardless if it's religious or not, that there are grounds there for your employment to be affected. This is why this case is so huge. This is why it's getting so much media attention. If you're thinking, what's happening? Why is it getting so much time on air? There is a huge legal outcome here. The entire employment relations, the entire HR, every employment lawyer is watching this case super carefully because the ramifications of the outcome are massive. Now, whether you side with the LGBT community and hope that Mr. Folau gets fired, whether you side with Mr. Folau and hope that he gets the damages that he's seeking, I think it's the tune of $10 million. Whichever side of the fence that you sit on, put your personal thoughts and feelings aside for 1 second and ask yourself this question, reflect on this question. Do you want employers to have more control, more input into the outcome of your employment with them, as in they can terminate you or not, based on what you post on social media if you're a religious person? Or do we want to ensure that religious people, that Muslims, Christians, Jewish people, Catholics, whoever you are, whatever walk of life, whatever God you pray to, that we want them to be able to post freely and have it not affect their employment whatsoever? Super fascinating. It is very, very interesting. When you have such strong and important aspects of your community, the religious community, our LGBT community, when they clash in this way, there is no clear-cut answers. It's not a simple they're right or they're wrong or they're right and they're wrong sort of thing. This is a very complicated and a very delicate situation, and the outcome of which will really and truly put the Fair Work Act of 2009 to the test in a court of law. I would love to just sit in that courtroom just to observe what happens. Let me know what you think. Let me know what your legal perspective is. Let me know which way you think it's going to go. Pop it all down to the comments. See you on the next episode.